Hey, everybody. Want to thank you again for joining me on another stream. Today, we are doing a follow-up from August 6th stream regarding the bankruptcy judge versus the United States trustee. Now, we may have seen the fallout, but this is what we're going to cover. What we talked about and what I shared with you last Thursday. Hey there, Rasmus. How you doing, everybody? So we're going to go over the deck and the information I shared, what's applicable, what's not. But before we get started, I do want to ask if you can subscribe to my channel. It will help me out tremendously. With that said, let's go ahead and play that approximately 20-minute audio recording from the bankruptcy court. I know you may have heard it all before, but it'll be a good lead in to what we cover today. So let's get started with that, shall we? And I'll go full screen. And here we go.
Schnitzel Ninja.
In the case 26-05144, Elizabeth Naylor and Ronald Owens.
Good afternoon. I'll take the appearances in the Owens and Naylor matter. Let's start first in the courtroom.
Thank you. Good afternoon, Your Honor. Jennifer G. I'm on behalf of the U.S. trustee.
Thank you. Good afternoon. And I'll take appearances from Mr. Owens and Ms. Naylor.
Yes, good afternoon, Your Honor. I am Elizabeth Ann Naylor, appearing pro se.
And I am Ronald Stephen Owens, also participating pro se.
Okay, thank you. Good afternoon.
Sure.
All right, let's go ahead and get started. We've got two matters on calendar. This is the time set for continued Chapter 11 status conference, as well as a hearing on the debtor's motion to dismiss this voluntary Chapter 11 case. I'm aware of the parties' filings, but let me turn it over to you to see how we wish to proceed. Shall I start with you, Ms. Jamo?
Thank you, Your Honor. Yes, so just to remind Your Honor, the debtors had filed.
Sorry, before we go further, I want to give credit to credit's due. Schnitzel Ninja posted this on her channel. So please, my friend Schnitzel Ninja can benefit by subscribing to her channel. We also saw it on All the Best, but I pulled up Schnitzel Ninja because she's a good friend of mine, and I just wanted to share that information to give kudos where kudos are due. Here we go. Back to it.
A motion to dismiss, and at the last hearing at which that was raised, Your Honor wisely pointed out that we needed to collect some documents and do more investigating before the case should be dismissed. I'm very glad that Your Honor had required that. We did receive what was called an accounting of the GoFundMe funds, and we received many bank statements that I was able to review. As the U.S. trustee laid out in her recent supplemental response to the motion to dismiss, there was some disturbing material that came out through our investigation. And for that reason, the U.S. trustee's position is that there's definitely bad faith here and the case should be either converted or dismissed. And also, as laid out in our supplemental response, we think that based on our analysis of the assets, that dismissal with a 2-year bar to refiling would be the wiser choice because there does not appear to be really any sure collectible assets in this case.
Right. Thank you. I did have an opportunity to review your supplemental response at docket number 89. Tell me more about why the recommendation.
Coming up, this is very important because the trustee, Jennifer Giamo, has addressed both the creditors as well as the debtors, the benefits to both of them to request a 2-year ban. So I think that was properly provided to the judge, and the judge did not think about it, as you'll see. But it is a nice way to say it, as well as supporting the 2-year ban versus a 1-year ban, which is probably the more normal process that a bankruptcy court in Arizona would do, or any other court. Here we go.
Is for a 2-year bar to refiling. Often we use a shorter period if there's a secured creditor looking to foreclose, or a longer period if we're looking for litigation to conclude. 2 years is pretty lengthy. So could you give me some additional information about that long period? And also, it's my understanding that Ms. Naylor and Mr. Owens have agreed to that period. Is that correct?
Yes, Your Honor. Yes, I should have pointed that out. Yes, Ms. Naylor and Mr. Owens, in correspondence with me, have indicated that they were willing to have the case dismissed with a 2-year bar to refiling. So the reason that we're asking for 2 years is because this case was filed in bad faith, we need to have a sufficient deterrent to prevent another repeat filing that would, again, interrupt creditors from pursuing their rights. 2 years, just weighing it, seems like an adequate amount of time to allow a foreclosure of the home to follow through if that's what's going to happen. I understand that there was a foreclosure set first in May, then I think it was reset to September. Now I believe it's reset to November. Ms. Naylor would know that information better. I don't know what is going on with that process, but it seems to me that that is the driving force behind these bankruptcies is the house, right? So I think that we absolutely need to give the creditor sufficient time to foreclose on the house if that's what's going to happen. I think 1 year might not necessarily do it, especially if they're trying to work something out. And so I feel like it's actually to the benefit of the debtors to have it be 2 years. So
Wait, did you just say it would be to the benefit of the debtors to be 2 years?
well, yeah, because maybe that gives because if there's that much leeway given to the mortgagee to foreclose on the property, maybe they'll be a little bit more willing to spend some time trying to work something out with them.
Oh, I see. So should the mortgage company have additional time during which Ms. Naylor and Mr. Owens cannot file bankruptcy, they may be willing to enter into negotiations during that elongated period.
Right. Exactly.
I understand. Thank you.
So there's that. And also there were 2 lawsuits against the debtors that those can proceed. And I think that based on the information that we discovered and laid out in our supplemental response, there are potential claims, I believe, by GoFundMe Inc. or donors. We definitely need to make sure that there's sufficient amount of time to allow those parties to pursue any rights if they choose. I mean, I have no involvement in that, but just based on my own investigation. So I think 2 years gives an adequate amount of time and is proportionate to the bad faith that we've seen here. And it gives an adequate amount of time to allow creditors to pursue their rights in state court, which is really what we want, right? That's the best interest of the creditors. And yet it doesn't completely foreclose the debtors from refiling should the need arise later, but there's a sufficient buffer with a 2-year bar so that creditors won't be harmed yet again.
Okay. Thank you for explaining that. One reason I had asked is just because there was the pending foreclosure sale. The court previously declined to extend the stay.
Yes.
And so it seemed that the mortgage company could move forward. Plus, under Arizona statutes, they could foreclose within 90 days anyway. So it just seemed like a long period. I hadn't really considered the idea that a longer period would actually motivate the mortgage company to engage in negotiations. Have you seen that happen before?
No, but I don't know why the mortgagee is continuing to move out the foreclosure date. So I'm assuming that they're working with them. That's all. I really don't know. I mean, I've tried to reach out to them and they've not really been very responsive to me, to the banks.
That's an interesting point. Why wouldn't the mortgagee attempt to contact from the trustee to talk with them? It just seems a little odd, doesn't it? Unless they're worried about what she was going to say or suggest, I don't know. But you would think they would at least let her know their plans or something to that effect if it's viable information that they can share, you know. But I do find that interesting that Jennifer did reach out to them and just haven't really made a successful connection or gather information so that she could put that in her filing. So we'll see what happens. We wish everybody good luck with everything, obviously, but you know, there's certain cases where things need to move forward in a different direction. So we'll continue again.
So, you know, that's just one factor, but I do believe that we should have sufficient time to allow creditors, not just the creditors that were listed in the schedule, but other potential claimants that I mentioned in our supplemental response to pursue claims against these debtors without a bad faith bankruptcy filing.
Okay. Another area of inquiry, and you did address it in your supplemental response, was just whether conversion would yield any distribution. I read what you wrote, and I certainly appreciate that trustees are loath to have cases where we have animals that need care and food, et cetera. It ends up costing them money as opposed to yielding benefits for creditors. So I certainly understand the reasoning of the U.S. trustee there. Is there anything else you want to tell me, not necessarily specifically with animals, but any of the other assets and the opportunities for recovery?
Well, Your Honor, I should mention to you that while the case was in a Chapter 13, there was a short time during which these debtors' case overlapped with the filing of a Chapter 7 case by the debtor's daughter, Laura Owens. And the attorney representing the Chapter 7 trustee in the Laura Owens case was Terry Dake. And I know that he was very actively looking into potential assets. And if you recall, there are some businesses that are co-owned by the daughter and either Miss Naylor alone or Miss Naylor and Mr. Owens with the daughter. And I did reach out to him to ask him what his professional opinion was as to whether the preferences made to the daughters is something that he looked into, and whether there was any assets that he could conceive of either in the Chapter 13 case or in the Chapter 7. And it was his opinion, just to me, in an informal discussion about it, that this did not seem like a good case for conversion. So we did factor that in. I didn't put it in the pleadings because it wasn't a real formal discussion. It was just something that I had run by him because of his familiarity with the case. But I did agree with his assessment based on my own analysis of all of the assets that are disclosed.
Okay, thank you for that additional information. And I do recall prior hearing you had mentioned Mr. Dake was involved in this case in some respect. So now I understand it's with the debtor's daughter.
Yes.
Okay.
Yes.
All right. What else do you want to tell me?
Your Honor, I think we just pretty much laid it out there. We think that there's definitely concerns, but in light of the financial situation, conversion would not make sense. It would be really a burden, I think, to any Chapter 7 trustee to ask them to take on such a case. So I do think that dismissal with a 2-year bar is the only way to handle it because of the bad faith. I do think there was a lot of bad faith, and that because of that, that's why we should have a little bit of a longer bar on refiling, because this is one of the worst I've seen in terms of misstatements, misrepresentations. So I would ask that that's what Your Honor do, especially in light of the fact that the debtors are agreeable to the 2-year bar.
All right. Thank you, Ms. Jamo.
Thank you.
All right. I note that there are a number of individuals who are appearing by Zoom. I'm wondering if there's anyone present who wishes to be heard before I return to Ms. Naylor and Mr. Owens.
Anyone? Bueller? I don't know if anyone would have spoken up. I'm sure if creditors were on the line in Zoom, they would probably have spoken up, and they may be there, but didn't speak up, right? So it was pretty interesting. The judge would give that offer out there, which is good, just to make sure she has all the information before she makes her decision before the end of this audio.
All right. Hearing no one speak, I'm going to go ahead and turn to you, Ms. Naylor and Mr. Owens. What do you want to advise the court at this time?
That we have reviewed the trustee's supplemental response. We agree with the final recommendation to dismiss the case with a 2-year bar, but we would like to state respectfully for the record that we dispute any insinuation of any sort of fraudulent intent or bad faith. As pro se debtors, the Chapter 11 reporting rules were very complex for us, and any omissions or anything like that were honest, unintentional mistakes that were due to our lack of counsel. And we feel we cooperated fully and provided any of the bank statements for 18 months, anything that we could to ensure total transparency.
Okay. So tell me about the 2-year bar date to refiling. What is your position with respect? It was represented in the record that there was a stipulation and agreement to that period.
We had had informal discussions with regard to that, and we had told the trustee that we were willing to go with a 2-year bar. I mean, frankly, we hope we are never, ever, ever in this situation again. And as we had explained before, we are trying to explore what options would be available for us to modify the mortgage and to come to agreements with the other creditors to resolve this outside of bankruptcy.
Okay. Are you engaging with your mortgage company or others in terms of in an effort to resolve those outstanding claims?
Yes, and we had, well, as far as the mortgage is concerned, we very much appreciated your suggestion that we work through the, I believe it's the MMM program through the bankruptcy court. And when we explored that, it appears that that would only come into play while we were actively in bankruptcy, and that once the case would be dismissed, that entire process would go away. So we have been trying to work through correspondence with the mortgage company, and we have again been told that in response to our latest communication with them, our latest letter with them, with the latest correspondence, that they will respond to us within 30 days. So perhaps that's why they maybe have moved out the foreclosure date more. But we are certainly wanting to work behind, the scenes I guess outside of bankruptcy court with them to resolve this.
Okay. So I'm pausing again. Pushing out the foreclosure 30 more days, we still have until September, what was your current, I believe, September or October, and now it's pushed out to November. I've been hearing that online. Why would they add another 30 days at the tail end? I mean, they already have time right now. So again, I don't understand the whole mortgage process, especially in a foreclosure situation. I've tried to learn about it here in Arizona, but I just find that that's a question I'd like to have answered. But will I get an answer? We don't know. I just found it interesting that they pushed it out an additional 30 days when there's still time currently on the clock. We will continue.
Okay. Well, very good. I wish you good luck in that regard.
Thank you. And thank you again for your recommendation on going through the mediation program in the court. We really wanted to work with that, but it just looks like that ends when the bankruptcy would be dismissed.
All right. What else do you want to tell me?
Just that I think regarding the GoFundMe campaign, we wanted to stress that there were no promises that were ever made to the donors, and that this was an effort that was the culmination of my husband's 5 decades on the air, and he and our family were very, very deeply touched by the outpouring of support from his listeners, who have truly become like an extended family to us over the last decade. So this was an appeal that was needed for housing and food and transportation and those kinds of things. And we were just very, very grateful for those contributions.
All right. Thank you. Anything further?
Not from me.
Okay. Mr. Owens, did you say something, sir?
No, I said not off the top of my head.
Okay. All right. Thank you. Let me turn back to Ms. Jamo. Anything further, ma'am?
No, Your Honor, I don't think it's necessary for the U.S. trustee to get into a back and forth with the Owens about the GoFundMe funds. Our pleadings speak for themselves, and it's not an issue that is going to be resolved here in any event. So we'll just leave it at that.
Okay. Let me ask you this. With respect to a dismissal, is the court's signed minute entry sufficient, or will your office wish to upload a formal order?
I think the court's minute entry would be fine. I don't want to have to deal with having to go back and forth and try to make sure that we're on the same page. I mean, especially because we have Ms. Naylor and Mr. Owens here on the record. You're seeing them here, I'm seeing them here, and it's clear that they're voluntarily agreeing to this. I would be comfortable with a minute entry of dismissal saying that there's It's a 2-year bar to refiling. Although I guess I wonder if we do need an order on the record so that if another case is filed, there's something more clear on the record.
The clerk's office should be able to pick up from the minute entry what we call an exception. And so it would be noted so that if another case is filed, it would trigger personal or direct review. Let me check with Ms. Hall and make sure I'm not mistaken in my understanding, but I think that's accurate.
Correct, Judge, and it would be in the ordering paragraph as well.
Okay. Right. So the minute entry will suffice for a bar date.
Perfect.
Okay.
That works.
So nothing else. And so Ms. Naylor and Mr. Owens, just so you're clear, I was just asking Ms. Jamo about the form of order that the court will issue. Generally, we issue a minute entry after every hearing, and I'm happy to sign that minute entry, and that will be the formal order of dismissal, and I was asking whether Ms. Jamo's office would prefer to have a specific form of order of dismissal. She's concluded, and I agree that that's not necessary. I'm just giving you the courtesy of asking whether for some reason you would like that.
No.
Okay. All right, then I'm prepared to make a ruling. Thank you, everyone. All right. So the matter before the court today is the debtor's motion to dismiss their voluntary Chapter 11 case. The debtors filed this motion, and afterward, the debtors and the United States Trustee's office have come to an agreement for dismissal of this case with prejudice, and they have agreed to dismiss with prejudice with a bar to refiling this case or any bankruptcy case for a period of 2 years. I've reviewed the motion. I've considered the parties' stipulation, the record in this case, and whatever arguments have been made by the parties. The court does find and conclude that cause exists under the United States Bankruptcy Code, Section 1112B, to dismiss this case. The record does demonstrate that the debtors have been unable to satisfy the obligations imposed under Chapter 11 and upon Chapter 11 debtors. And it's also clear that there's no reasonable likelihood that this case can proceed to a successful reorganization within a reasonable period of time. The court further finds that dismissal rather than conversion is in the best interest of the creditors and the estate. I've considered the scope and the nature of assets and the potential for transfers that could be avoided or other claims. And it appears that that would be very difficult and costly for any Chapter 7 trustee to undertake. The remaining question is the scope of any prejudice to refiling. Although the parties have stipulated to a 2-year refiling bar, I believe it's incumbent upon the court to independently determine whether that requested relief is warranted under the Bankruptcy Code and the facts of the case. In particular, since we haven't had an evidentiary hearing, a dismissal with prejudice and a prohibition on refiling constitute extraordinary relief. And generally, the court's rule is that such a bar should extend no further than necessary to address the conduct that has been presented to the court. So again, I do find that cause exists to impose a refiling bar. The record reflects significant failures to comply with the requirements of Chapter 11 and demonstrates that dismissal without prejudice would not adequately protect the integrity of the bankruptcy process. Accordingly, a period during which debtors may not seek relief in bankruptcy is appropriate. The court is also persuaded by the multiple errors, the misstatements, and even possible misrepresentations that the present record does justify a 2-year prohibition on refiling. The court concludes that a 2-year bar will accomplish the purposes of 11 U.S.C. Section 105A and 349A. A 2-year refiling bar adequately protects the bankruptcy process, discourages abusive or premature refilings, and is appropriately tailored to the circumstances of this case. In particular, because the debtors have consented to that 2-year bar. And Ms. Giamo points out an unusual and perhaps novel consideration the court had not previously considered, which is that with more time provided to the mortgage company, perhaps the parties can enter into an agreement or arrangement that meets all the parties' needs with respect to the real property. So for these reasons, the debtor's motion to dismiss is granted. This Chapter 11 case is dismissed under 11 U.S.C. Section 1112B. The dismissal is with prejudice to the filing of any bankruptcy petition by either debtor under any chapter of the Bankruptcy Code for a period of 2 years from the date of the entry of the dismissal order, which shall be the minute entry that will emanate from this hearing. I'm not expecting any additional form of order. Rather, as soon as this minute entry is filed, the case will be dismissed, and that will be the end of the matter. And with that, I believe everything that we were here for today has been considered and concluded. Is there anything else we need to discuss, Mr. Owens and Ms. Naylor?
Nothing.
No, just thank you very much for allowing us to appear via Zoom with the heat today. It's a lot more comfortable for my husband and for me. So thank you.
Great. Well, you're welcome and good luck. Ms. Jamo, anything further, ma'am?
Nothing further from the U.S. trustee. Thank you very much, Your Honor.
All right. With that, then we are adjourned. Thank you, everyone. Good luck.
Thank you.
Thank you.
Schnitzel Ninja! Schnitzel Ninja!
So we got through that, which is nice. And it kind of gives you lay down what happened on Thursday's hearing, August 6th. Going through what I provided on my last stream, let me make that bigger for us. So initially, I explained how Chapter 11 bankruptcy provisions and judicial notice and such, it's not applicable here. You can still see the list of Chapter 13 and Chapter 11 hearings that were in place or activity that occurred. Judge's options, everything was not applicable except at the bottom, impose alternate sanctions or conditions. So the court can maintain supervision, order further compliance actions, or require specific restrictions short of a full multi-year refiling ban. She stuck with the 2-year ban and no supervision, but they did dismiss the Chapter 11. So that opens the door for the creditors to file what they need to do to retrieve their monies. Judge Wainsley did a pretty good job overall, I think. She came in hardcore at the beginning and she took all the evidence and to make her own judicial decision. So I was appreciative of that. And again, whether a bankruptcy judge accepts or rejects a U.S. trustee's recommendation does not directly determine or trigger criminal charges. So keep that in mind. This doesn't automatically mean there will be an investigation, whatever government entity that decides to do it, if they do it all. So we don't know where it may come next, but we obviously want to be cognizant of what could occur. Separation of civil administrative actions and criminal prosecution. The judge oversees the administration of the bankruptcy state. Again, not applicable because it was dismissed. And referral for investigation. She chose not to do that, as we saw. And it doesn't mean that some other government agency won't pick it up, right? They may have all been aware of this and looking into it. So we don't know what the future holds. I don't think they know what the future holds for themselves, except the fact that the possibility exists that the foreclosure may not occur due to working with the mortgagee. So we shall see what happens there. Nikki adds a comment here. Nikki says, the bankruptcy filings clearly show in the GFM accounting they use funds to pay for criminal legal bills. That's strictly prohibited on GFM. They show spending more on that than on medical. Well, and the facts don't lie, right? What was submitted by these folks under oath, signed and under oath, is now public information, or at least in the bankruptcy court filings, right? That information is out there for other agencies to look into. And Sarah, I agree with you on that one. Back to this, potential criminal offenses. Yes, we heard about a lot coming out of Jennifer. From Jennifer's perspective, during the hearing, I believe it was July 16th. So if you hadn't heard that one, that's out there also on Schnitzel's website, as well as all the best. not website, YouTube channel, as well as All the Best, and I think Volo's website. You can find it there also. The role of intent. To secure a criminal conviction, federal prosecutors must prove beyond a reasonable doubt that a person acted knowingly and fraudulently with the intent to deceive rather than committing an honest mistake, poor booking, error, or oversight. Now, people do say that the Chapter 11 is very convoluted, very difficult to get through, and all that. But documents were provided under oath, right, that best attempts still showed some inconsistencies, as Jennifer pointed out in that July 16th hearing. So knowingly or not knowingly, those documents were provided. So if someone put their pen to paper and decided to put that information all together. So it does make you stop and think, if truth and justice prevails, those would be concerning issues. As Nikki just pointed out, that you cannot use GFM funding for any criminal related activity and then, sorry, I'm watching a very variety of comments. Thank you so much. So GFM may step in on this also. Don't forget, they may have some issues going on behind the scenes. We don't know, or they may be waiting for this to be dismissed before they move forward. Something to watch for. Unrestricted access to state remedies. Creditors no longer have to wait beyond a bankruptcy trustee. That's very important because the creditors have been waiting for so long to collect their monies. And don't forget, I would assume there'd be interest on top of the balance, right, over time. And I think that as creditors do deserve their rights to be respected, just like debtors, that they deserve avenues to secure their money or retrieve their money back. So we shall see any of those cases that may come to the courts. It's very feasible. And also the foreclosure process. We shall see what happens in that realm. Any new information, of course, I will provide it, and as well as many other streamers and content creators that are doing the same thing. No estate distribution from a trustee, because the U.S. trustee found no meaningful pool of unencumbered or non-exempt assets to liquidate. Creditors will not receive any financial payout through a bankruptcy. So keep that in mind. Now that the bankruptcy's been dismissed, they can go after the debtors in their own way and with what information they can gather via the bankruptcy documents, as well as what they already have in their possession. Again, when you sign on a mortgage, you are committing to paying the bill. So resume foreclosure sales. Yes, that will continue. I did research that. And even though it's been pushed out to November, no matter what, by law in Arizona, they cannot backtrack a date, like set it for tomorrow instead. They have to stick with the date they have, or they can move it out, but they cannot bring it forward. Does that make sense to everybody? Because I expected that, I thought after the dismissal of the bankruptcy, they may move the foreclosure date sooner, but that's not possible in Arizona's law. Pursue civil lawsuits and judgments. Yes, they have those options to them available to every and all creditors. And I know Jennifer had mentioned that the debtor should list all of the donors on the GFM, because any and all of them could file in civil court to retrieve their money due to a variety of reasons. More importantly, the possible alleged misrepresentation of the write-up. So keep that in mind too. May or may not go anywhere, could become a class action suit. I don't know. I'm not a legal lawyer at all. I just am learning from the internet, reading the Arizona laws and trying to understand all the specifics. Garnishment and liens, you know how that goes. Enforce independent collections, because the dismissal bypasses a Chapter 7 coordination. Creditors do not have to wait for the coordination. Spoke about that already, which is good. Now, as far as Social Security benefits, private creditors cannot touch them at all. None of the others also. Credit cards, utility bills, personal loans, things along those lines. Government and special exceptions. I brought this up last Thursday. Social Security benefits can be garnished or offset for specific public debts, like unpaid federal taxes, the IRS can take up to 15% of monthly benefits, child support or alimony up to 65%, federal student loans defaulted on federal loans can result up to 15%. I didn't know some of this is not applicable, but it all ties in. So I just wanted to share as much information so that you're aware of what is impacted by government and special exceptions. Federal agency overpayment. Social Security Administration itself can withhold funds to recover prior benefit overpayments, legal battles to claim exemptions. Now, keep this in mind that if there is currently health insurance and there was health insurance, there could be a case for defrauding the agency, okay, and the coverage that was received. I don't know any more details than that, but it does make you stop and think because there's so much going on in the government regarding recent filing on millions of dollars in Medicare misuse, right? So there's been some crackdown on that. And I do believe President Trump has at one point, stopped funding Medicare because of such things as that. So who knows if this will go forward in that realm, but it is something that may be considered. Pension and retirement plans, private pensions, 401ks, federal, military, state, and local pensions. The bank account trap. This was brought up again on Thursday. I know Big Tiff Dog did that, talked about this also. When you commingle funds, which has been literally the same word used in the hearing, July 16th. And it was an interesting way to say that agreed to the fact that debtors commingled their money by having the GoFundMe going into the same checking account as their Social Security benefits as well as the pension amount. So now that all that money's in play, commingled, right? It protected pensions or Social Security funds are mixed in the same checking account with other non-exempt monies, such as general business income or taxable wages. Maybe one of the LLCs also use that same account. It becomes much harder to prove to a court which dollar is which, sometimes exposing the account to freezes or extensive legal battles to claim exemptions. And we did see that in some of the filings that Jennifer talked about with the debtors about what they listed under the GFM. And I understand from their perspective, they're trying to be transparent, but they did list things that were possibly inappropriate where the funds should have gone. And I know many people have spoken out about the misrepresentation in the verbiage on the GFM. It implies, and it could be interpreted differently than the intent. So that is a concern because you never know how people perceive things and what they want to donate for in what they thought they were donating for versus what it was spent on. You know what I mean? So we'll see what happens with that too, but it is a concern. It's active. So if you want to donate, please do help them out. Arizona specific bankruptcy laws and quirks. Opt out of federal exemptions. We don't do that here. The massive Arizona homestead exempt. Yep, I believe it's $400K. Arizona strict lack of wildcard exemption. We don't do that here. Nope, we don't do that here. Specific personal property caps, the itemized list, the rule. Arizona law tightly caps specific everyday items. For example, standard limits apply to household goods, electronics, a single motor vehicle, and specific items like wedding rings or firearms. Okay, so good, I guess, but you are limited. So be careful what you write as personal property. So now going to comments, let's see what we have. Nikki suggests a letter writing campaign to GFM. So it would be interesting if that's something that people want to start doing or reading out. I can't lead that. So if you want to, that could be quite interesting to see what what would come out of it. Do you know what I mean? Because again, as Megan showed us years ago, that a hard letter, a physical letter being sent in makes a big difference versus comments online or sending an electronic email, let's say. Still useful, but not as powerful because it takes resources to go through every hard copy physical letter to open and read and consolidate. So Nikki also adds, I've been involved in outing a few YouTube GFM scams over the years. GFM will refund the donors if the organizers don't work with them to repay. Then they'll go after them legally. Insurance covers this. Interesting, Nikki. You found several of those already, eh? So that's good information to know, because not just in this case, but there are other folks out there that are doing this, doing a GoFundMe and then not properly spending the funds collected appropriately, I should say. So let's all be careful about the GoFundMe accounts or requests or submissions, right, to collect monies. You got to be really on top of things. Almost have a lawyer review it before you do it. Oh, that kind of rhymed. Alana adds, yes, that is correct. Monies can be retrieved. You never know. Nikki also adds, you can't use GFM for criminal cases, and they showed it admitted in their accounting that they sent $3,500 of it to a lawyer, even admitted to Queen Jennifer Diamo, they did. GFM are legally bound to act. So we shall see if that letter campaign that you had suggested earlier, if people follow through on that. I wonder if GoFundMe will follow through themselves. It is a valid point, because it does make them look bad, right, as a source, which then could send people to other sites if they're going to continue doing crowdsourcing for funds. And they need to stick to their own rules. If that could be a stream by itself. What does GoFundMe terms and conditions, right? Terms and agreements, whatever. May have to do that just so I'll record it. But it might be worth it so everybody is aware of what their current status is. Sarah, GFM terms say something about not being truthful about who is in charge of the GFM donations. I looked at it a while ago. Well, that's good information too, because we do have an organizer by initials, but we also heard under oath that one of the debtors is taking full responsibility for it. So it's kind of a mix and match, right? We want to be careful of taking full responsibility. It could be to your disadvantage, and the person who did create it should be held accountable. Sarah asks a good question. Where do we send stuff to complain? And Nikki adds, GFM take people who have donated more seriously. When complaining is the GFM is still up now. Yes, Nikki, the GFM is still up now, and it's increasing because we do have, you can see that there are monthly donations scheduled. So they get donated. It does increase periodically with additional new ones, people submitting, which if it goes to the right, if it's allocated correctly, then it's a good thing, right? For his health. That would be my interpretation, because healthcare costs are expensive, but if you have coverage, the costs aren't as bad as it could be without health insurance. Nikki makes it easy to complain whether a donor or not, Sarah. It's found from their main page menu or going onto the campaign and reporting it through the option at the bottom. Okay, thank you, Nikki. If you want to email me a link or anything, that would be great. If not, I will go find it myself and try to add it to my description on this stream. But it's not a bad idea. It does make you stop and think, though. You may think twice before donating to any of the fundraisings, because you want to make sure it's going to a valid recipient for valid reasons. And it's concerning to a lot of people because there are, like Nikki pointed out, she's already come across several that were not legit, if you will, or did not spend the funds accordingly as described in the write-up on the site. So, you're going to find stuff like that in almost any area of the world, but I think it's great that Nikki is focused on that and got some of those taken down, because that's good money going away that we could use for other things like food, shelter, things that we need to survive. Our own active daily living issues. Yeah, you got that right, Nikki. Even $5 can add up in our own pockets. So, does anybody have any questions regarding the audio recording? Do you have any questions about where we stand today? If I can answer them, I'd be more than willing to. If I can't, I'll jot them down and we can drop them, or you can drop them in the comments. That's another option. And I'll review the comments later and answer what I can after researching, of course. So that's a harsh one, Nikki. I hear what you're saying. Nikki writes, I have YouTube examples of GFM scams faking cancer where we've uncovered. I'll email you them. Thank you so much, Nikki. I appreciate that. It is a sad state of affairs because that's not even anything that you should play around with, right? It's a horrible, horrible disease. And anyone who's been through cancer and survived, like myself, you don't want to have people taking advantage of that. You've never been through it. You shouldn't be touching that one. That's a hard one for anybody to find out there's a scam going on, right? It's not a claim that anyone should take or make, I should say. What else can I share with you? We went over the audio. I went over the follow-up for the aftermath from last Thursday. And let's see, Nikki adds, my thing is they admit to leasing a pony, does not, but Jan says 25,000, said 0 on a few months earlier. Yeah, the inconsistency on the documents really make a big difference. They were all signed under oath. They were all filed with the courts and then either voluntarily dismissed or dismissed via the judge in this case. But that information, like I said, there are other government agencies that may take all that information and consolidate it and see where the inconsistencies are. And that could be troublesome. Remember, it doesn't mean that just because a judge didn't submit for an investigation that they won't be investigated. So you have to take that into consideration too. If you ever get in a situation, be as honest as possible. A, don't get in this situation. B, be as honest as possible. You don't want something to come back at you later because you'll be on pins and needles waiting for something to hit the fan, so to speak. Well, Sarah, that's a good idea. If you trust the organizer and what it's for, and you know them, that kind of thing, yes, that's a good place to donate, knowing that the funds are going to be spent or allocated correctly. When you're submitting donations for others, it's almost like the Judge Judy adage: if you loan money to somebody, it's no longer a loan. Just treat it as you're not going to receive it back. Give it from the heart, but don't do a loan, right? Same thing with the donations. In this case, you may get your money back, but usually when people donate, they're giving it from the heart based on what the situation is, and they wouldn't expect a return on it, right? The only thing I would expect is a thank you, right? A big thank you. So that would be most important to me. Teresa adds, GFM has been investigated a number of times for hosting fraudulent GFMs, and they have done other very shady things. So GoFundMe is also in the news, if you will. I'll have to look into that specifically also, because I don't want that to be, you know what I mean? I don't want that to be something that people can't go to for legitimate purposes. I would hate to find out that people, it gets shut down for their illegal activity. Again, allegedly in this case, but possible. But if they're shut down, then people don't have an avenue. They'll have to find another one. Now, we do know of several other fundraising sites that are used, but you want to be careful. Again, if you're not familiar with them, look at their terms and agreements. So I think I will do a stream on that for the two that I'm aware of. I think it's important to know that because if each of us have to go out and go read it, A, you won't have time to do it. B, we all get a different interpretation. So if I do a stream on those, I think that would be beneficial to the group versus each of us doing it on our own. And we can share our comments, concerns that on that stream together. So we all learn. If you like that idea, let me know. Otherwise, I'm still doing it. So Teresa followed up with JFM without permission scraped the internet and added thousands of nonprofits. Wow. Just to build their clientele or their site. I gotcha. That's how I interpret what you said. Yeah. Yeah. If someone calculated all the anonymous donations from this GFM, it's over $40,000. Now, we do know of some that submitted small amounts, right? But there's some pretty good sized ones also. And even throughout, with names attached, quite good sizes. So they must have a lot of people that are know them or understand their situation from what was written, right? And that's what they're basing their donations on. So that makes a big difference. That's why you have to be careful what you write and how you write it and what implications or what you're implying versus what is being written. And even though you may have meant it one way, people can interpret it another. So you really have to take the time to write that correctly. You know what I mean? So you're not leading anybody down the wrong path because you don't want people to come back to have an issue. Thank you, Sarah. I appreciate that. It makes a world of difference, you know, because once you find some flaw, it becomes a negative mark on them. And then people stop using them. Or more and more dirt gets uncovered. As Nikki's pointed out, she's seen several YTs. She's seen several campaigns, right? So it is make you stop and think, is it even worth it? You know, but it shouldn't be taken away from the general public for crowdsourcing. I mean, that's helped quite a few people over the years, decades even, right? So Teresa brings up, it was 1.4 million auto-generated GFM pages in 2025. Backlash ensued, then reversal. They scraped IRS records. Ouch. Lawsuits were filed. They are as scummy and scammy as others. Oh man, Teresa, that's deep. That was just last year. Wow. But they're still up and running, right? That's the amazing part. And don't forget that you also have to pay a percentage, right? So they collect money on each campaign, each and every campaign. So if anybody donates anything, they're making money off it. So based on what you wrote here, Teresa, I find it odd that they're still up and running. So I'll have to look into that, or unless somebody knows how they got away with it, I don't understand. Plus IRS records, I just assume that's private. Maybe I'm wrong, but it does make you stop and think what it's all about, right? It's intended to do good to help others, right? That's the whole premise of it. So why taint it? Why do anything to cause it a negative? And it just bothers me to no end, right? Because people can benefit from that and change lives, especially children who may have a life-threatening disease and they need the monies to pay for hospital stay and surgeries and things along those lines, or anybody for that matter. But you do put yourself out there and you have to hope that people trust what you're writing, and you better be writing what you're saying, what the truth, basically, right? Yeah, I hear you, Nikki. It is mind-boggling. They really are doing a good thing overall, the intent, but to be penalized unless they, as they've done bad, but if they didn't do anything bad, they shouldn't be penalized for what they offer to the public, So Nikki adds, GFM gets scammed a lot. Their insurance is crazy. And she also follows that up with, that's why it survives, because it intends to do good and does, but they take advantage and their platform isn't secure enough and leaves people vulnerable. That's a valid statement. Thank you so much, Nikki, for concisely stating what I've been trying to say, right? Because it does. They have a valid good intent, but the platform probably doesn't have the appropriate security to keep it from maintaining only legit cases. Campaigns, shall we say. And people are vulnerable to that. Nikki, sorry, Teresa, I don't think GFM is off the hook yet. I hope not. And all those should be reported to the Arizona Attorney General. Yes. If anybody finds any kind of illegal activity, you should report it. And as my missing spotlight series, I've always mentioning the FBI local office. I'm representing the FBI website. Local law enforcement is always available to you to bring something to their attention. Let them transfer it to the correct group and investigate. It's all worth their time, the time overall for those phone calls or those investigations to take place. As long as they're valid and you have somewhat of a proof understanding to provide them, the law enforcement locally is a great source to reach out to. Nikki writes, you're doing a great job, Rob. They need more staff to look over things and scrutinize claims rather than depending on AI. Thank you, Nikki. I appreciate that. And it wasn't just for that about me, but it was more about like the dependent on AI. Yeah, that's kind of difficult. Even in StreamYard, some of my shorts or videos get knocked, and then it says if you reviewed it and it doesn't seem like it should be knocked, then you can submit this for human review. And so far, every time the human review comes back, you are correct. You're back to your video is available for full access and not limited earnings. So that's really important, right? Because just because AI found something inappropriate doesn't mean it's inappropriate. And my best example is my monthly Maricopa County Attorney Office's news alerts. They use verbiage because a crime was committed. I say DV, I say SA. Sometimes I'll say other words because it's in the title or it's in the paragraph, but it shouldn't be removed. It's good information to let you know what the crime was committed, who the criminal is, and what happened to that criminal, right? So it shouldn't be pulled back or not receive the credibility. I think it's worth it anybody to do in their own areas, right? All it is news alerts coming out. Now, we went from the internet limitations to now social media limitations. Well, they're kind of one and the same. So it gets frustrating to me when you start picking on a social media or content creator versus an internet website. Really, you define it for me, the difference, and then let's go from there. But it's all online. And I think that the laws should be looked into and addressed and tweaked or updated. How about that? Updated would be a good word. Yes, Nikki, I agree. More humans, less robots. It would be job security. It would give us much more legitimate responses and reviews, and people would be able to understand. They wouldn't have as much work because they do it right the first time, where AI is doing the best they can, but they're not able to do everything. Like I said, with my MCAO monthly reports, right? They will still catch something, and that's just how they're coded or programmed. But do you think my little stream is going to go anywhere? Do you think mine's going to change the world? I don't think anybody should think that. I just talk like everybody else. So it's all good information. So let's see. Teresa says there are 20 stars attorney generals that launched investigations. Where are the other 30? Oh, okay. Of the states. Yep. State attorney generals, 20 out of 50. And it is a valid point, Teresa. If people are not bringing it to their attention, if it's not that big a deal in their state, how they review them, I really don't know, but each state has been different, as you've seen on YouTube. When we watch a video from one state versus another, the laws are different, down at that level. Yes, I agree, Nikki. The AI verification, even within YouTube, is a challenge, to say the least. That's very good, Sarah. Never trust a device you aren't willing to throw out the third story window. That's awesome. Yes, I know. I got the stars turned into states. Sorry, Teresa. I should have said it that way. Sarah, now I get it. Very good point. So, okay, so I will, you'll see my stream tomorrow at 3 p.m. It'll come out at 3, and then I plan to stream again at 3 on Wednesday live. Tomorrow will be a video record, so you'll see that. Wednesday, I'll stream live on another topical topic. What? Topical topic. So if you want to join me on Wednesday at 3 p.m., that would be great. If not, please watch my replays. Also, if you can recommend to others to subscribe to my channel, it would be very helpful to me and much appreciated. And I will not bother you with that again today, but I will in the future. Okay, everybody. Thanks so much. I appreciate your time. I'm so happy you're here. And I will see you on the next one. Okay. Take care. Bye.